Welcome to the SCV Law Life Podcast. I'm Mason Rashtian. Each week I sit down with people in the legal world and beyond to talk about the strategies that are actually working for them in law, in life, and everything in between. Real conversations, real lessons, and ideas you can actually use. Let's get into it. Welcome back to the SCV Law Life Podcast, where we explore people, professions, and ideas that impact our community and our lives. I'm your host, Mason Rashtian, founder of the Mason Law Firm, and today we're joined by someone who has spent more than 4 decades helping people resolve conflict in a productive and meaningful way. Our guest is Ronald Monitz, an accomplished attorney and certified mediator with over 40 years of legal experience. Throughout his career, Ron has handled disputes ranging from business and real estate conflicts to construction, intellectual property, commercial litigation, partnership agreements, and disagreements, and even deeply personal disputes. In addition to his extensive litigation background, Ron has devoted more than 15 years to mediation, serving on numerous mediation and arbitration panels, including the American Arbitration Association, the Los Angeles Superior Court mediation panels, and the California State Bar. He has also served as a Judge Pro Tem for the Los Angeles Superior Court, presiding over hundreds of small claims and traffic matters. His commitment to the profession has earned him an AV Preeminent rating with Martindale-Hubbell and recognition as a super lawyer. What makes Ron's approach especially interesting is that he believes successful mediation isn't just about legal analysis. It's about empathy, active listening, trust, creativity, and helping people move beyond conflict toward practical, long-term solutions that work for everyone involved. Today, we'll discuss what mediation really is, how it differs from litigation and arbitration, why so many disputes are resolved outside the courtroom, and the strategies that help people and individuals and businesses avoid unnecessary legal battles. Whether you're an attorney, a business owner, or someone facing a difficult dispute, this conversation is filled with practical insights that can change the way you think about conflict resolution. Please join me in welcoming Ronald Monitz to the SCV Law Life Podcast. Hi, Ron.
Hi, Mason. Thank you for that intro.
How are you?
I feel humbled and embarrassed, but I'm glad to be here. Glad to be here.
You deserve all of it. None of it is a lie. It's all true. You've done all of it. You're the man.
I'm just another guy, and we'll see. But I do like to help people. And I really was upset with the cost of litigation and how normal people couldn't do it. And as a result, after being an arbitrator and a judge pro tem and a lawyer, of course, I really focus now on mediation because that's the best method for people to resolve, as we're going to talk about here today. That's the best available method for disputants, that's the people who are disputing, for them to resolve it without going to court, without spending the money, without spending years, without getting the stress, and they get the best resolution. And we'll talk about that.
Okay.
So what is mediation, right? People have asked me, they go, what's the difference between mediation and arbitration? They don't know what mediation is. Well, mediation is a process where the disputants get together with a neutral third party, the mediator, and they resolve the dispute. And it's voluntary. It's strictly voluntary. They want to do it. You can't make somebody mediate. You can make somebody go to court. You can file a lawsuit, serve him, and then he has to go to court. But mediation is for people who want to avoid litigation and want to resolve it with all the benefits that we're talking about today. And even more importantly, the resolution is in the control of the parties. They're in absolute control. Only when they agree is it over. Unlike in a court, of course, the judge makes a decision, arbitration, the arbitrator makes a decision, but in mediation, it's the people in the dispute that actually make the resolution. Why is that good? because first of all, they like the resolution better and they're going to honor it. Not always true, in litigation.
Can I ask you one question? Now,
Sure.
you could be in litigation and still have mediation. So it's not just avoiding litigation altogether. Some parties aren't in litigation. For example, a lawsuit has been filed, but you still choose to go to mediation to resolve it without going to trial.
Excellent. And that's exactly true. People who are in litigation could still opt to mediate. And in fact, the Superior Court of Los Angeles mandatorily sends people to mediation before trial so that people can save the trial costs. I'm on the panel. I'm on two panels with the Los Angeles Superior Court. One's the MVP panel, one's the Resolve panel. And so you can avoid the cost of trial too by saying, you know what, let's go to mediation now, and people do that. You can also just hire a mediator without the court appointing you, but it's never too late to mediate.
You can mediate during trial sometimes.
You can. And the best thing about mediation is that it's confidential. Not so for litigation, but by statute, what is said in mediation is confidential. If people are mediating and they don't like it and they say, I'm going to go to court, nothing that's said in mediation is admissible or can be repeated in court. And you'd be surprised if somebody says what you said in mediation, you get sanctions. It's a bad thing for disclosing it. So it's actually confidential, and it makes it better for sort of private things you don't want to have public.
Yeah, I mean, so for people to understand, so you can go to court and you cannot say to the jury, the other side offered me X amount of dollars of mediation. That is a complete no-no.
Right. And don't forget, every settlement offer is inadmissible. It's not just that. If you're in mediation and you say, okay, I was speeding and I crashed into you, or yes, I breached the contract. They can't say that either. They can't say, oh, by the way, he admits he breached the contract. Can't say it, and you don't have to admit it in court. So it's just something that you could use as a settlement tool, mediation, but it's what's said in mediation stays in mediation. You've heard that before, right?
Oh, yeah.
And another beauty of mediation is that if the mediator is wrong or is saying something that's stupid, you can just tell the mediator no. And you could say you've got it all wrong. You can really let the mediator have it if you feel like it, and sometimes you do. And you can't do that with a judge, and you can't do that with an arbitrator because you're probably going to end up on the losing side. But you can tell the mediator whatever you want, and then you can call the mediation over, and whatever you said is all, it's confidential. It never happens. And so that's how that works. And
I can safely say, I've been in tons of mediation as a defense attorney, as a plaintiff's attorney. I'm also part of the LA Resolve panel council for LA courts. I can only recall once or twice that I ever disagreed or yelled at a mediator. And I remember it was when I first opened my office 20 years ago as a plaintiff's attorney, and the mediator was completely dead wrong on a subject, to a point where I had to send him the case law afterwards to show him that he was wrong. But usually you guys know the law from both sides, and you guys know exactly what positions you should take.
Yeah. Well, you've raised an important point. As a litigator for decades, I've gone to many mediations where somebody else was the mediator, and I was disappointed in the mediation and the mediator many, many times, because you know what? Not every mediator is a good mediator. Many mediations are wastes of time. So it's important, and we'll talk about some of the characteristics you want to look for, but it's important that you get a mediator that you trust. And as you said, some mediators don't know the law. They don't know the law of the subject that they're mediating about. I mean, it's outrageous. They don't have to be the mediator for every case they're not qualified for, but for some reason they do.
So tell us about some of the cases that you mediate.
Well, who should mediate? I'll tell you in a second, but first I want to tell you there's 3 different types of mediation, and people don't know that. I mean, I became a certified mediator because I just didn't want to mediate like I do with my kids. But there's 3 types of mediation. First one is called facilitative mediation. That's when the mediator facilitates, he helps the parties reach their resolution by helping them explore their ideas and saying, okay, that's, any other ideas you have? And he goes back and forth with the different presentations and ideas from one side to the other and says, this is what about this and what about this? And he helps them do it because some people have a hard time talking to their opponent. And so many mediations are done by Zoom. And many disputants never talk to the other side in a mediation. They just speak with the mediator, who then goes to the other side for them. So that's their choice, but you don't have to speak to the other side. But a facilitator listens to what you have to say and then goes to the other side with it and tries to basically split the baby between the two different ideas. That's probably the most common method of mediation, and it's not my favorite, but it's very common. Facilitated mediation. Let me help you get to the midpoint here. The second method is called evaluative mediation, and that's where this mediator, unlike the facilitator, this mediator will give you his opinions of your ideas and your positions if you're in litigation. He'll even give you strengths and weaknesses of your case. And a facilitator won't do that. But in an evaluative methodology, they do that. And that's useful when a party wants a reality check, especially if they're in litigation. Do I have a good case? Am I going to win this case? How many times have I been asked, am I going to win this case? So some people do want an evaluative measure, and not every mediator does that. So that's one of the questions you want to know when you're looking for a mediator. What sort of methodology do you use? The third method is called transformative. It's the least used of all the mediation technologies, and very few people use it, but it's an excellent method. What it does is it transforms the two opinions of the disputants. They come in sometimes and they hate the guy. Could be a neighbor dispute. They really hate the guy. Or they don't trust him. And anything he says, they just come in with those views. And in the transformative methodology, you actually transform that view. You help the party see, where are the shoes of the other disputant and sort of understand. For example, some guy's driving crazy, he's cutting through lanes and he's passing everybody and then he crashes into you and causes you damage. And here you are at the mediation. And in the mediation, you find out that one, he says, I'm really sorry what I did. It's not me. I'm a regular guy. I'm really, really sorry. I'm sorry I caused you that damage. But my wife was in the hospital and I was told I have to get there and I was in a hurry. I was rushing. I did the wrong thing. And it was, I'm declaring insanity. It was crazy, but that's not who I am. And sometimes people go, maybe he's not so bad after all, but transformative works. And all of these styles work at the right place and for the right people. And people who like one, I don't think are great mediators. I use all of them, and you have to know all of them and use all of them sometimes. So understand that, and it gives you some clues about what you should be looking for in a mediator instead of just going, anybody know him? And then somebody goes, yeah, I used him, he was good. Good for what, right? So those are important things to know.
Do you have a preference between the 3 of them? I know you use all 3 of them, but do you have personally?
I don't have a preference because really one is the better way for some people and one is the better way for other people.
Yeah. I like the evaluative one for a lot of reasons. Number one is sometimes I need a third person to tell my client what I've been telling them, because sometimes they just need to hear from somebody else who's just as much experienced as I do. That helps a lot. And number two is I'd like to know if I have any weaknesses that for some reason, I'm not seeing on both, for both sides. So I think that, to me, that usually helps out better than just somebody who just goes around and, gives a message from one to the other one. That's all they're doing.
Yeah. He says 50. What do you say? Who needs a messenger, right?
Exactly. Yeah.
What you say reminds me, people have to know. You can meet with the mediator and talk to the mediator, and you have the option of bringing your lawyer. You don't have to bring a lawyer, but you can, and you can rely on your lawyer and use your lawyer to talk to the mediator. So if you want a mediator, you bring your lawyer or don't. It's up to you. And lawyers like you're right. I've got that before. Lawyers are interested in whether they have a winner or a loser and what they have to work on to make it a better winner and what are their weak spots. They do ask that, and they're entitled to it, right? It's part of, can we resolve it today or not, right? Now, disputants, they need certain basic needs. When they're here, they're in a dispute, they're feeling angry, nervous. Yes, I have basic needs. So what are those needs? One, they need dignity. It's got to be dignified. We're going to resolve this, but I need my dignity. They need fairness. They need autonomy. They're in charge of their decisions. They need safety. Nobody wants to be in a mediation where the big bully they've been dealing with is sitting next to them and is just intimidating them. A mediator's got to ensure safety. And that's why I said sometimes people just want to be on Zoom and they want to be in their home and they don't want to be near that other person, and that's fine too. But they're entitled to safety, whether we're all together or not. And they're entitled to understanding. As a small claims judge, I let everybody tell me their story, no matter how long it took, because I was convinced that everybody needed their day in court. They needed to be heard and to be understood. And that's a basic need. And I'm telling you now that when I ruled against somebody who got the chance to say why they thought they were the winner, they didn't mind that they lost. And I explained why they're wrong. The fact that they were heard and understood, it really helped on the disputes. And finally, what you need trust. You need to trust the person you're talking to. And these basic needs aren't always satisfied, maybe rarely satisfied in litigation or arbitration for that matter. And so that's why I'm telling people their best methodology, really, if you want to resolve a dispute, think about it, realize that mediation's there, and you should try it, do it. If it doesn't work, you have the right to say it's over. You say, I'm done. Because the mediator doesn't know what he's talking about, because I just changed my mind. You're in control.
So what kind of matters do you handle?
Now,
you're frozen, Ron. Sorry.
You want to know sort of the benefits. What are benefits?
Ron, you're frozen. There you go. You're back.
Okay. I get so excited with this mediation stuff, I just freeze. Let's talk about the benefits. Are there any benefits to mediation? The answer is yes. First benefit is cost. As a big firm lawyer, and big firms had high attorney fees and high amounts in dispute, hourly fees were high, and then the total fees were high. I mean, attorney fees got to be hundreds of thousands of dollars regularly and millions of dollars. And even for small law firms, it's $50,000 to handle a case and go to trial. It's tens of thousands of dollars minimum, even if the other side gives up. So it's costly. But in mediation, it's hundreds of dollars. Okay, I'm charging $400 an hour, which is lower than any mediator you've ever met, and I know. And a 3-hour mediation, and virtually all of my mediations get done in 3 hours. Virtually all of them. So, and that's $1,200 that's split between the two sides. So they're done in one day with their dispute for $600. So cost is a benefit. You can't resolve a dispute in court for hundreds of dollars or an arbitration for hundreds of dollars. In fact, the arbitrator gets paid more than that for his first hour. So cost is one benefit. Time is another benefit. In mediation, I get things done in hours. Always days. One day could be 2 days. Almost never beyond 2 days, to tell the truth. Unless a lawyer says I need to come back because I need to get more discovery or come back a second day. But for the parties who want to resolve their dispute without going to court, you can get it done fast in a day, and it's over. Another benefit is control. You as a party are in control. You decide what you're going to say. You decide how it's going to resolve. You don't get that anywhere else. That's only a mediation. Another benefit, which I love, is atmosphere. As I said, most people want to do it in Zoom from their own home. They've got a cup of coffee, they're relaxed. That's not the way it is in a court. That's not the way it is in arbitration. The atmosphere is very stressful. But even when I'm doing them live, I have people distant from each other. Everybody's got their own space. The atmosphere, everybody's got to be very courteous to everybody else. There's no insults allowed. And the atmosphere is terrific to help resolve a dispute.
Yeah, one thing I tell my clients when they tell me, I want to go to trial, I'm ready to go to trial, and I have to explain to them, okay, let's think about this. You're going to have to sit in a courtroom from 8:30 to 4 p.m. every day. You're missing time from work. And guess what? You got 12 juries staring down at you, and everything you do is going to be analyzed, right, by somebody. You're right. It's extremely stressful, but clients don't really understand that. You have to explain that to them, how stressful it is at trial versus a mediation where nowadays, you're right. At Zoom, you can have a cup of coffee, and here it goes, and everything is more comfortable. Yeah.
And it's stressful when they testify at trial. When they're testifying at trial, that's stressful. But in mediation, we're just having a conversation. You just say what you want to say, and nobody can repeat it. And actually, that's the next point. The next benefit is confidentiality. That is a benefit because people don't want their private affairs to be in public records where anybody else can look it up and read it, see what your spouse said about you, see what wrongdoing happened in your family. And the confidentiality is worth the price of admission. It's a great benefit. Another benefit is the outcome. In litigation, I call it a win-lose outcome. Somebody wins and somebody loses. Same thing in arbitration. But in mediation, it's a win-win because you're both agreeing and getting what you want. And I'm very good at this. We'll talk about why, but I don't let people mediate for a bad resolution. Sometimes somebody's being bullied in something, and I won't let them get away. I won't let that happen. But what I do is I look for the best alternative that's available to each of these people as we sit there. As a lawyer, people come to me and they have problems. One, they got sued. Or two, somebody did them dirty and they have to sue somebody. Right? And nobody came to me and said, hey, I'm having a great day. I just want you to know it's a wonderful day. It was always a problem. And I said, you've got lots of bad options available to you. For example, you can pay, $50,000 for litigation fees and let's go teach him a lesson. That's a bad option of sorts, but there's some, it's an option. You can let it go and say, hey, that's save my $50,000, let it go. That's an option. It's a bad option, right? You could lose the case after spending $50,000 or more, and that's a bad option, right? You can try and settle, but then the number isn't good, and then if you settle for too low, then you hate yourself for the rest of your life and go, I wish I should have gone, then you have this. I said, you got lots of bad options. So let's try and figure out what's your best option here. Mm-hmm. And in mediation, that's what we do. Lots of choices for each dispute. There's a lot of choices available. And we come up with the best solution. And when they see it and we can get one that's the best for both of them, boy, they jump at it and they get the best outcome.
If I say one thing, I think you said that in trial, there's always a winner and a loser. That's not always the case. You can have two losers at trial because one of them could win, but the amount of money they spend to get that verdict at the end of the day could substantially reduce what they end up with. So they could potentially be both losers, plain and simple. Happens all the time.
You're absolutely right. And I was blessed. I won all my cases. Now, not because I was so great, but if it was a sure loser, I did settle. But I won all my cases, but the clients didn't always feel that they won. I would get an award for attorney's fees, but the guy didn't have the attorney's fees, so they couldn't get it back. So you're right. Sometimes it's lose-lose in litigation. The last benefit that I like to tell people about is relationships. When you're done with litigation, those relationships are over. But when you're done with mediation, the relationships are preserved. Why does that matter? We'll talk about who needs these mediations. But I've mediated probate disputes. Mom dies, the children are arguing, and the siblings aren't speaking to each other. And after we get done with the mediation, they're speaking again. And so you can save that relationship. There's neighbors have disputes. You can save that relationship with mediation, not in litigation. Anyway, you get it. Mediation saves relationships. Okay. What else do I want to tell you? Because I need you guys to learn all this stuff.
Well, so tell me, before we do that, tell us how people can get a hold of you if they need your services.
Wow, thank you so much. There is a website out in the world called monitzmediation.com. I can scream my phone number out here.
If you like to, it's totally up to you. But website is probably sufficient. If that's what you want.
Somebody can get a hold. They can read more about me and get some testimonials. And who needs that, right? But I'm available 24/7, and I've always said I've had mediations over the weekend. I've had mediations at night. As a lawyer, I never said no to anybody. I said, I'm going to help you, and what's the time? And I do that with me as a mediator. Somebody needs this to happen, tomorrow night, because then it's going to happen tomorrow night. Because I want people to resolve their disputes for like no money, just let's get it done.
Right. And what kind of matters do you handle?
Okay, let's talk about that. So who needs it? I do neighbor disputes. I do landlord-tenant disputes. I do consumer good disputes. That's like people fighting over goods or services or refunds or returns, against this commercial entity. I do family disputes. And there are family disputes, and that's the way to do it. You don't want to litigate, and you can mediate, and it can get resolved. And you still stay family. I have done spousal disputes, boyfriend-girlfriend disputes. They bought a house together, and then they break up, and now what are we going to do? And now you need a mediator, unfortunately. Better than going to court and spending money, right? I do business disputes. I do partnership disputes and breaches of contract, alleged fraud. Every lawyer, when they sue for breach of contract, they always add a claim for fraud, saying, the guy said he's going to do this, but he didn't really mean it, so I'm adding a fraud claim. So people keep accusing people of fraud. It's not always fraud, but there's a lot of breaches of contracts, and those can get resolved relatively quickly. I do probate disputes, as I told you, and I do workplace disputes between employers and employees, and disputes between employees and employees. And those are good places to save the relationships, right?
Absolutely, yes.
All right, so look, I know I've kept you all day. I'm sorry I talk so much, but I want people to know that mediation exists. People don't know it. You can do it. It gets started fast. And look, I also offer everybody 30 minutes, a free 30 minutes to ask me, let's talk about it, to see if it's a good dispute that you should mediate. If it isn't, I'll tell you, you can't mediate it. Why? Because the other side isn't going to agree to mediation and will never agree to anything we say. And you need the other side to want to agree about something. And if you won't agree on anything, then let's not mediate.
Yeah. So I'm not sure if you tell us the basic difference between mediation and arbitration.
Well, you've heard about mediation and litigation. Arbitration is litigation with a judge. You pick the judge as opposed to getting it assigned by the court. So you have some sense of who the judge is going to be, which is great. The two sides say, let's agree this is going to be our judge. And that's better than litigation. But unlike litigation, you have to pay for your rented judge. He isn't paid by the city. You have to pay him. And he charges, $800, $900 an hour, something like that. And you have to pay him for every hour that he's going to be working with you. The other thing that's different is that you present your case to the arbitrator, and he decides what the result is going to be singly. It's his decision. You tell him why you think you should win. The other side says why they should win, and the judge says who wins. A mediator, I don't just say who wins. I have a lot of tools. I have a lot of arrows in my quiver that judges and arbitrators don't have. For example, in one dispute between an employer and employee, I used a letter of apology to apologize to the employee who was a good employee, but got insulted in front of all the other employees and sort of started being a little less a good employee. And then the employer who missed the good employee started getting mad at him and said, I'm ready to fire you. And the employee sued. He said, this is a hostile environment. And when I found out that the employer liked that employee but insulted him, and the employee said, I love this place, but he insulted me, I used a letter of apology to work out, get things a little better. That's the transformative world. And we worked out a deal where he then returned to work and everybody was happy. You don't have a letter of apology as a judge or an arbitrator. Another time with a landlord-tenant dispute, the tenant didn't have that money then, but he was going to get it. And I modified, I suggested, I didn't get to do it. I just said, what about this, guys? What if we modify the rent for these 2 months, boost it back up, and you stay here for these 2 months at a reduced rent, and then you pay everything later when he was getting a sum of money that he was getting in 3 months. I said, and you guys can be happy. You don't have to go to trial on this thing. And they all love that. They said, that's great. I can modify things, and you need a mediator who thinks outside the box, who just doesn't say who wins, who says, let's see if I can make you both winners. That's what you need.
Okay. All right. And so I think you told us you got into this because you want to help people resolve their disputes. Tell me.
For no money. For no money.
A little bit of money, because there's the mediators fee.
For a little bit of money. For a little bit of money.
Compared to the cost of litigation, yeah, and especially trial, it's peanuts. So that's true. Yeah, and you get a sense of relief. You know what you're getting. You get to control the outcome. It's great. Okay.
Let me have like 30 seconds to tell you this.
Yeah.
You need to have certain characteristics, skill sets of a mediator, and judges don't have it. I mean, how many lawyers say, I want to get a mediator as a judge, a retired judge? Let me tell you what you need. Of course, you need somebody to be impartial. That goes without saying. That's a judge too. But you need somebody who's empathetic. You need somebody who's compassionate. You need somebody who's an active listener. A judge is usually pretty good about cutting you off because he's read the papers and knows what to say. You need an active listener who can get to the bottom of what this dispute's all about. Sometimes a dispute's a prior dispute that still angers somebody, and the mediator has to know that and play that into resolving it. You need somebody who's respectful. You need somebody who has patience. You need somebody who understands the law that you're battling, for sure. And you need somebody who's creative, and you need somebody who has a reasonable fee. Don't pay too much for lawyers or for mediators or for arbitrators. Just pay what's fair.
So now that we discussed that part, tell us about you. Who's Ron? What do you like to do? Hobbies?
Well,
tell us about yourself.
Well, I had 4 kids. I say I had 4 kids, and people say, "Oh, sorry, what happened?" I say now they're 4 adults, but and my hobby was being a dad, as crazy as that sounds, and being at their places and doing things and being with them and going to ball games with them. So I do that a lot. I do love going to plays more so than movies. I like seeing live performers, and I can clap for them and they can appreciate that. And occasionally I'm invited, because I'm a bad poker player. I'm invited when somebody's missing a player, they send a limo to get me to make sure I'm there. So I do play poker with some friends sometimes, and I make friends that way because I lose, so that's good.
Do you have any grandkids?
No grandkids yet.
Okay. So you say ball games. What we're we talking about? Baseball games, I assume?
Baseball was my first favorite. And then football games. I would do football games with the boys. That was their favorite. And those are the better. I've gone to basketball games, of course. Had to see LeBron a few times, even when he was on Cleveland. I saw him. So I would see sports and enjoy sports. So that is fun.
Okay, I'm gonna have to ask you, who's your baseball team?
The Dodgers are my baseball team.
Yeah, you better say that, because you know what? I've got my Dodger hat. I've got my Sandy Koufax bobblehead doll, and I've got my son got this for me. It's actually a Shaq bobblehead doll in a Dodger uniform. Check that out.
Oh, that's great. Well, first of all, I was born in New York and came to LA, like the Dodgers. So, there's a kinship there. And one of my favorite players, maybe my favorite player, was Steve Garvey. And I saw Steve Garvey when I took my sons to a baseball card show, and there was Steve Garvey. And I said, Steve Garvey, yeah, he was so great. I remember your dad was the bus driver in Vero Beach and you were meant to be a Dodger. I said, it killed me when the Dodgers traded you. I felt so bad when they traded you to San Diego. It just killed me. And he looked at me and goes, me too.
So do you think they should the trade deadline's coming up, right? So obviously they need a backup catcher. They may not get another pitcher. Any ideas what they should do if you're the manager or the general manager?
Yeah. I do think they have to get a relief pitcher. They did go out and get one who got injured. They need a relief pitcher and they have to go get him. Yeah. And they need a starter, but I keep hoping that these starters are coming back, but they need a starter because they've got 3 questionable starters right now out of the 5. So they could use a starter and a reliever and they'll be ready. All
right. Okay.
All right.
So we'll
go to a Dodger game together.
Absolutely.
Right.
Before we wrap it up, let me ask you a question I ask all my guests. As you sit here today, based on your knowledge, if you were to see your 10-year-old self, 10-year-old Ron, what advice would you give him?
Wow. He was a good kid. My 10-year-old son was a big fan of watching The Lone Ranger. Lone Ranger, black and white show, was on TV. And I watched that all the time. And The Lone Ranger was good. And there were bad people in the show. And he would go get them and he would fix them and, resolve that. And I developed a right versus wrong sort of mentality. And I, as a 10-year-old, if somebody was wrong, I just want to fix it and I want to get it because I want to just right. And I would tell that 10-year-old, you don't have to fix the wrong. You can sort of work together, be my mediator. You could work together and get a better result than just being the right one and being right and then making him wrong and be the loser. So be a little more tolerant of people that are wrong and help make them better and get a win-win.
Yeah, great advice. So one more time, how can people get a hold of you?
They can come to my website, monitzmediation.com, or they can call you, and I'm sure you've got my number somewhere.
Yeah, right. Thank you so much for being a guest, and for everyone who's listening and watching, if you like this, please like and subscribe to our podcast for future episodes. Thank you again.
Thank you. Bye-bye.
Thanks for listening to the SCV Law and Life Podcast. If today's conversation gave you something to think about, make sure to follow or subscribe so you don't miss future episodes. I'm Mason Rashtian, and I'll see you next time for more conversations on law, life, and what really moves the needle.